Jillian Merchants, first of all, who's an employment law expert with Thompsons Solicitors. Jillian, good morning.
Good morning.
Right, a very measured response there from Jane. Clearly in her position, she says she doesn't have to recheck her behaviour because her behaviour is exemplary, just the kind of person that you want in workplaces across the country. But nevertheless, can you appreciate that there might still be confusion out there about what constitutes sexual harassment? Where do we actually stand?
I mean, I don't think there is confusion, and I think any confusion that there is has been really overblown. I mean, in terms of the Equality Act, it's quite clear that, sexual harassment is basically unwanted conduct of a sexual nature which violates someone's dignity or creates an intimidating and degrading and offensive working environment. So as far as I'm concerned, that's pretty clear. And, the courts will look at, when they're considering whether or not the complaint is of harassment, they'll look at the perception of normally the woman who's experienced the conduct in the circumstances of the case. And they'll also look at whether or not it was reasonable for the conduct to have that effect. So there is kind of that secondary element to it that will allow an objective and a subjective test.
Mm-hmm. What is the legal definition of harassment?
I mean, under the Equality Act, there's kind of two definitions. So you've got harassment on the grounds of a protected characteristic, so that's like age, disability, sexual orientation, things like that. So obviously people, or their race, people face harassment because of that. And that is, it's very similar. It's just unwanted conduct which has the purpose of violating someone's dignity or creating an intimidating environment. And the sexual harassment is the same, apart from it doesn't have to relate to like your age or your gender or anything like that.
And if it's a one-off, can that still be taken forward, or does it have to be repetitive? Does it have to be a pattern?
No, it doesn't have to be a pattern.
So this can be a one-off incident that has made the recipient feel very uncomfortable, feel exposed, feel vulnerable, etc. They have grounds for taking that forward?
Yes.
Okay. Do you think, in your experience as an employment lawyer, since this movement has been gathering momentum, are you now dealing more with employers out there who are keen to try and bring in a fresh approach to the workplace? Are you being contacted by employers to say, right, give me some advice, where do we stand on this, and what do we need to do as a responsible employer to make sure that our workforce is safe?
I mean, I'm sure there probably are those questions being asked. I mean, at Thompsons, we only work for employees, so it's not really something that the employers would contact us about. But I think that there is certainly, a movement towards ensuring that employers have clear policies about sexual harassment. I think it was over the weekend that Sheryl Sandberg, the Facebook Chief Operating Officer, had said that she thinks that part of this is about the lack of clear policies that employers have. And obviously that's something that seems to be quite widespread. So I think that it's certainly provoked thought amongst employers as to how they deal with that and how they ensure that their managers are suitably trained to deal with those types of allegations in the workplace.
Jillian, in a word, do you think we are clearer about what constitutes sexual harassment?
Yes.